I think that human rights are rights and freedoms that we in Australia all get to enjoy simply because we're human. Some people think that there's 4 concepts that underline human rights, and they are universal. So this means that they apply to everyone regardless of the country you grew up in, your religious beliefs or your gender. They're also inalienable, which means that no one can take them away from you. Also, they're indivisible, which means that they all rank equally with each other, and also that they're inherent, so we get them purely because we're human beings. It's important to remember that human rights don't just float around in the air. They require the state and big players in the state like judges or politicians to recognise them and give them some weight. They're not a legal right, so therefore don't necessarily have the same weight as a legal right. So in the actual situation of, I guess, the real world, there can be circumstances where 2 human rights are going to be clashing, and one's possibly going to have to be ignored at the expense of another, and they're not actually going to rate equally because they're not given that weighting or power. A good example of a human right is the right to privacy. The right to privacy is given its international power, I guess, through the International Covenant on Civil and Political Rights. In Australia, I guess we all pretty much agree that there should be a right to privacy, but we can't quite point to where it gets its legitimacy from. One option is for a right at common law. This would develop through a tort. In 1937, there was a High Court case, Victoria Park Racing and Taylor. In this case, the High Court suggested that having a right to privacy at common law possibly wasn't something that Australia should be looking towards. However, in 2001, in the Australian Broadcasting Corporation and Lee Nargay Meats case, the High Court has left open the possibility to such a tort developing. Another possibility of how we could give legal weighting to the right to privacy is through the currently proposed tort, which is actually a statutory tort that the government has proposed. This would be just one law that covers all instances of a breach to privacy. In my opinion, I really think that the best option would be to go with the common law. The common law, through the tort system, would provide a more tailored response to the specific breach of privacy. For example, we've already got things at common law that already protect your privacy. Things like defamation laws, confidentiality. I think that this is probably the best option to go for. If we contrast this with a statutory protection, we can look at the UK. The UK have a Human Rights Act. It might be well and good, but if we look at the examples such as the News of the World scandal that's recently rocked the UK, it's pretty clear that this Human Rights Act didn't actually have any effective remedies. The right to free speech is a really important human right. It's given its weighting in both the Universal Declaration of Human Rights and the International Covenant on Civil and Political Rights. We all know how important the right to free speech is. For example, how many times have you heard in films or any sort of entertainment Americans talk about the First Amendment? This is where, in America, they were given the constitutional amendment, giving them a strict right to free speech. Other countries like South Africa, India and Japan have such a direct legal right. We in Australia don't have any statutory protection for the right to free speech. But how would you feel if you saw a wrong and you couldn't speak up against it? As I was saying before, in Australia, a lot of human rights aren't actually legal rights. So what we saw before was that privacy in Australia has a limited protection and free speech has none. So the impact of, say, creating a legal right to privacy will have negative impacts on free speech because it has no protection. This means that when you're looking at giving any human rights some sort of legal weighting, you're going to elevate it above other ones that don't have such protections. So when you're doing this, at the same time, you need to give consideration to all other related human rights. A relatively recent example of where there's been a conflict of rights is the 2006 case in New Zealand of Brown and the Attorney General. Why this case is so newsworthy is that a convicted pedophile actually gained compensation of $25,000. The background facts of the case are that there was a pedophile, Brown. He was released from jail after serving his time and was rehoused in a suburb in Wellington in New Zealand. A concerned policeman noticed that Brown was rehoused in this particular suburb, and he thought that it was an inappropriate place for him to be. In response to this, the policeman created a flyer. The flyer indicated who Mr. Brown was through a photo and also other background information. Mr. Brown claimed that this was a breach of his privacy. He also claimed that this overrode any right that the community had to knowing that he was there. What is really interesting about this case is that we probably feel that the policeman was doing the right thing. In fact, the Pedophile Parole Board actually, when they found out where Mr. Brown had been located, also agreed that he was in the wrong place and subsequently rehoused him. I guess what's difficult is this case shows what happens when one right is given a legal power, so the right to privacy, whereas the other one isn't. How would you feel if this was your neighbourhood and you weren't able to know who was living there? Essentially, the most important thing to remember when you are going to give legal weight to one right is how it impacts on other rights that may not have any legal protection. It's the job of Parliament when they're passing statutory rights to really focus on these issues.